Good morning, Ms. Butler.
Good morning, Judge Easter.
Do you wish to have any rebuttal time?
I would like to reserve 4 minutes for rebuttal, please.
Okay, 4 minutes.
Good morning, Your Honors. May it please the Court. Jessica Butler with the Appellate Division of the Public Defender's Conference on behalf of the appellant, Mr. Marlos Tipton. The facts are somewhat in dispute here, but I think the fairest...
They are in dispute, is what you said?
Yes,
Okay.
the facts are in dispute, but I think the fairest interpretation is that Mr. Tipton was driving on the interstate at approximately 1 a.m. At some point, he made some contact with the victim's Hummer. The victim was not wearing a seatbelt, was injured, and ultimately succumbed to those injuries. Mr. Tipton was charged with 1 count of vehicular homicide and 1 count of speeding. He proceeded to a bench trial, represented himself as a pro se defendant, and was convicted as charged. We've raised 2 issues in the brief: the sufficiency of the evidence and the trial court's denial of Mr. Tipton's motion for an expert funding. I'm going to focus on the second issue today and rest on the briefs with regards to the sufficiency, unless the court has specific questions. It was very clear from sort of the early portions of the pretrial that the central piece of evidence in this case would be the data that was retrieved from a black box in Mr. Tipton's Camry. The state was very clear about this pretrial, had a report prepared, stated at the motion hearing that it was intending to call Trooper Moore, a member of the critical incident response team, as an expert at the trial. And so Mr. Tipton filed a motion asking for funding for his own expert, essentially sort of trying to find something resembling parity in terms of being able to argue in his defense. The state in its brief has argued that Mr. Tipton did not establish a particularized need. I want to point out that the state's also sort of arguing that we have changed course a bit in terms of the argument that we made below and the argument that we're making today. And I just want to be clear that I think it's fair to say that how it's framed in the brief is maybe not verbatim how it was framed at trial. I think the court can kind of parse through why that might be. But in essence, the sort of structural argument has remained the same from the motion to the motion hearing to the briefs to the argument today. The argument has always been that the state intended to call an expert in this case. Well, before we even get to the point of calling an expert, the state had an expert. That expert prepared a report that was turned over in discovery, and then the expert was called to testify at trial.
But wasn't there a lack of, I don't want to say a lack of clarity, but was it unclear prior to trial whether this trooper would actually be tendered as an expert?
So the trial court did sort of mention that during the motion hearing. I'm not sure that there was all that much confusion about whether or not the trooper would be tendered. Certainly the state thought that he would be and mentioned that they would submit a CV into discovery for Mr. Tipton to review. But I think even if the trooper had not been tendered as an expert, that doesn't negate Mr. Tipton's need for an expert. Obviously, the state had already had the trooper prepare the report, so he'd already reviewed the evidence. He'd already reviewed this sort of like very technical black box data. He'd prepared a report. Presumably, he had had a conversation with the DA and had explained sort of how it works. I'm not a car person, but I can tell you it would have been nice to have somebody who was when reviewing it, because it's not exactly just very cut and dry. There are some really technical components to it. So at a minimum, he'd reviewed it, prepared the report, and then sort of explained it in a shorthand to the state before proceeding to trial.
I'm sorry, go ahead,
No,
Judge.
go ahead.
I was just going to ask, outside of the black box findings, did the report contain any other opinions that we would generally consider to come from an expert, like skid mark measurements, things of that nature?
There were not skid mark measurements per se. There was some discussion about the skid marks and sort of how there were some photos of the skid marks from the scene. There was some discussion in the report about sort of what those would indicate. in the trooper's opinion, but I don't recall any specific markings. And in fact, that was something that Mr. Tipton sort of raised as well, that there wasn't a whole lot outside of the black box data itself to sort of tie this to a vehicular homicide. It was mostly the black box data, and there were some photos of the crime scene after the fact, but there wasn't anything beyond that.
Do you have to be an expert, qualified as an expert, to testify about the black box data? I mean, can just a, I don't want to say it this way, but, you know, a regular state trooper who's familiar with reading those reports, can he testify to the black box data, or do you have to have an expert?
I would say probably, I don't think that just a standard trooper could testify, and certainly the state didn't think so either, because they had a second trooper testify before Trooper Moore got up to testify, and he was not tendered as an expert and didn't really discuss the black box data at all. And of course, obviously the trial court also thought that the black box data was sufficiently technical to warrant an expert opinion, because he did ultimately tender the trooper as an expert. So I do think that and having seen it myself, again, I'm not a car person, but I do think that it is sufficiently technical to warrant an expert opinion.
And I ask that because if it's clear to everybody in the courtroom that witness X has to be an expert in order to testify to this data, then it's really a question for the state. But then, I mean, how is it not obvious at that point that the defense is at least entitled to have an expert at least review that material? Okay, like I said,
Yes,
it's a question for the state. I'm thinking,
and that's exactly our argument, Your Honor, is that the particularized need was pretty apparent from how the hearing sort of transpired. The state obviously was present for the hearing, which isn't typically how that's done, but the state was present, made it clear that they had this report, they intended to use it, they intended to tender Trooper Moore as an expert. So I think regardless of sort of how elegant Mr. Tipton's arguments were, I think that it was pretty apparent to the trial court and everyone in the courtroom that this was really set up to be sort of a battle of the experts case, but we only have one expert.
what about the subpoena that was or was not issued for someone? I mean, can you explain that a little bit more? Because, you know, it seems like your client at least had spoken to somebody, whether they're technically an expert in what we're talking about or not, I don't know, but who had at least said to him, this probably was the other person's fault.
Right.
And the trial judge did agree to issue a subpoena for that person, but then your client never called him at trial?
So I'm not, yes, I think it's a little confusing, but I think the best that I can explain it is there was some discussion about whether or not the subpoena could actually be served on that individual, because Mr. Tipton only had, I believe, a P.O. box on record. I don't think that he had like a physical address that he could send the subpoena to, and so there was some discussion about whether or not they could send a subpoena to a P.O. box. Obviously, Mr. Tipton argued that, you know, that's how the state receives their mail. How can someone else not receive a subpoena through those avenues? But the trial court seemed to indicate that they can't serve subpoenas via the P.O. box, but then sort of conceded that they would serve the subpoena. And to my knowledge, that never happened. It's not in the record, I don't believe. And obviously that person was not present on the day of trial. So what transpired after the hearing in terms of the subpoena, I'm not sure. But that person, I think, I don't think that person was ever the person that Mr. Tipton had in mind for the collision expert. I think that was, at least to analyze the black box data, I think that was a sort of separate issue, and I'm not really sure why that ended up not getting resolved. I just want to point out that the case law here in Rule 13 obviously require the trial court not to give Mr. Tipton, you know, the leading expert in Camry black box data or anything. But the case law, Ake and Barnett, do require the trial court to give basic tools for an adequate defense. And again, like I said, this was really set up to be sort of a battle of the experts type of case. That was the central component of the state's case. They really never sort of wavered from that. They did obviously call the other members, the other people who were in the car, but outside of that, that was really the state's case, is that they had the black box data that indicated that Mr. Tipton was traveling at an excessive speed. And so, leaving Mr. Tipton with no recourse with his own expert, obviously severely sort of hamstrung his ability to mount an adequate defense in this case.
How clearly, though, and we've kind of danced around this a little bit, but how clearly was that need articulated to the trial court by the defendant prior to trial? Because the state's saying, look, this is conclusory. Based upon what the trial judge knew at the time, he made the correct decision. And certainly I read your brief and some things come out at trial where you kind of say, well, that's interesting. But was that, we're judging the trial judge's, the propriety of his ruling at the time based upon what he knew. So how clearly was that articulated?
I think that it was articulated sufficiently. So I guess what I'll say, obviously we have sort of fleshed it out a bit more in the brief. But as I said, sort of the structural argument hasn't changed. Mr. Tipton was really clear at the hearing that if the state was allowed to have an expert, he also felt that he needed an expert. And of course, the state obviously is saying this evidence is very critical to our argument, our theory of the case. And I would argue that if it's that important to the state's case, it's equally as important to Mr. Tipton's defense, if not more so, because that is sort of the hinge point of the state's case, and obviously that would be his defense as well. So I think, obviously, yes, there are some tangents and such at the hearing, but I think we sort of always come back to this point that if the state is allowed to call an expert, not even call an expert, if the state's allowed to have an expert review this data, make a report, sort of explain to counsel how this all works, and then potentially testify at trial, Mr. Tipton felt that he should be entitled to as much.
So that's the sum of it. They have an expert, I want one.
I think that's the sum of it, yes.
So in every homicide case, under that reasoning, a defendant would be entitled to an independent medical examiner to conduct an independent autopsy.
I see your point, but
They'd have to show something additional, right? They'd have to say, I need this expert because I have this particularized need.
Right, and I do think that Mr. Tipton raised at the hearing that he had some issues with the report. That there were some discrepancies that he didn't agree with. Obviously, they get into more of that at the trial, but he did at the motion hearing mention that he did not trust the report, he did not trust the trooper's analysis. Obviously, having been there, he took issue with some of what was in the report. And so I don't think it's just they have an expert, I want one. I think it's they have an expert, I want one, and also I don't think that the report is accurate. And I think that combination gets us to that's a particularized need.
But kind of piggybacking on that as well, I mean, just saying I don't think the report is accurate, is that enough to express a particularized need? Because same thing in his homicide case, you can just say, I just disagree with the medical examiner. And therefore you get an independent medical examiner?
Well, no, but I think my assumption is that it is not always common for the autopsy to be sort of the central piece of evidence at the trial. It is one piece, it's obviously an important component, but it's rarely the singular sort of cornerstone of the state's case. Here, it was absolutely the singular component of the state's case, and that's why it was so critically important for Mr. Tipton, who was a pro se defendant, who was indigent, to have at least the same opportunity to have someone review that and explain it to him. And I also want to just point out that, again, the trial court didn't really give an explanation for why it was denying the motion. There's some discussion about, well, I'm not sure that they're going to be tendered as an expert anyway. Again, as I said, I don't think that that really gets to the issue, whether the trooper testifies as an expert or not. They've already used him as an expert. And the other thing is, he sort of says, well, I think what you're really concerned about is sort of embracing the ultimate issue, that the trooper's going to get up there and say, you're at fault. So I'm not going to let them do that. And then obviously, that's exactly what happened at the trial, is that the trooper got up there, essentially said, I found that Mr. Tipton was the proximate cause of the wreck and therefore of the victim's death. Mr. Tipton objected, the trial court let it in anyway. So sort of all of the issues that Mr. Tipton had were sort of realized at the trial. And I think as the court looks at the transcript, it's readily apparent sort of why that was necessary, because there's a lengthy sort of back and forth between Mr. Tipton and Trooper Moore about the specifics of the report, and the trooper sort of just like discounts at every turn and says, well, you're really focusing on this one point, and I'll agree with you that maybe there are some discrepancies, but they don't really matter because what matters is the speed is accurate, and that's sort of all we need to know. And I think that that really calls into question whether, you know, the veracity of that, given that we only have one expert here and one sort of set of facts to go on. So I will stop there. We'd ask the court to reverse and remand. Thank you.
Thank you, ma'am. Mr. May?
Good morning. Kirby May on behalf of the state. I'm substituted in for Abigail Renard for the sole purposes of oral arguments. Very briefly on sufficiency, because the defense counsel repeatedly stated that this was the sole crux of the evidence and proof. This case was about two vehicles traveling, one Hummer driving 70 miles an hour on the interstate, eastbound on I-40 near exit 106. That was struck by the defendant's vehicle, which was exceeding that speed. The surviving victims both testified. One testified that he saw the car and it was going very quickly, approaching him from the rear. The other one said all he noticed was they got struck, they started spinning out, and eventually went off the road and flipped and crunched. The rear seat passenger, died. She was not restrained and was tossed around the car and tossed out of the car and crushed by the car and died on the scene, if I remember correctly. There were two troopers that arrived on the scene, a Trooper Rivera and a Trooper Forsyth, who investigated, having no information as to the airbag modules in either the victim's car or the defendant's car, and that's when we were talking about the data that the defense is solely talking about is the data from the Camry, the defendant's car. But there was also, were not also aware at the time that there was a GPS monitor on the defendant's car, which corroborated the data from the airbag module of the defendant's car. But they looked solely at the crime scene, or the crash scene, the markings on the road, the damage to the cars, and that's one thing. Just very quickly, it's sufficiency of evidence. Looking at I think it's exhibits 2 or 3 and 9, which show the defendant's car and the absolute crunching and the compaction of the front hood of the car, as well as the significant damage to the front right fender of the car, which showed, consistent with what the officers, the troopers on the scene that night saw, was it was a rear-end crash that struck the left center of the Hummer. They were both traveling in the left lane, the fast lane as we would call it, and sending it yawing and spinning and eventually hitting off the road and flipping off the road. They were consistent with that. Then Officer Trooper Moore, arrived at the scene the next day, investigated the scene the next day, as well as then he was the one that had the search warrants and analyzed or had the data from both the victim's cars and the defendant's cars, as well as the GPS. And that's the data we're talking about. Nowhere at the trial, and this trial came out, as defense noted, this was a pro se. The trial court attempted on numerous times, you will see from the record, to appoint him an attorney, and either from the public defender's office or elsewise, and he refused. He filed numerous motions that are in the record as well, numerous issues in regards to this case, pro se. And at this hearing date on, I think it was December 6th, he had filed this petition, this one particular petition as regards to the expert. All it simply stated was, an expert collision witness is material to the defendant's defense. That's all it stated. And as your honors know, that Tennessee Supreme Court Rule 13 is very explicit in the requirements of what is needed to entail to proceed. and including it says that shall itemize the nature of the services requested. That might possibly hit that, but there was no particularized in this petition itself. And then it shows the name, the information as to the expert that you're seeking to retain. Nothing is in that. And to this day, there's no information on who, if he had contacted anybody or who it would have been. The only information, as Judge Dyer said, he mentioned at that hearing a lady from the Tennessee Department of Safety and provided that information to the court, and the court and counsel, the prosecution, attempted to get information so they could issue the subpoena. There's no information whether the subpoena was served, whether that witness was arrived, or was called
Let
testimony.
me ask you just procedurally.
Yes.
If a litigant, pro se or represented, files a document like you're talking about that just says an expert witness is material to the defense, we would all agree, hey, maybe that doesn't cover the rule. Can they flesh that out, though, in the hearing? And so I file a very generic document saying I need an expert because it's material to the defense, and then we get to the hearing, and let's just say in this case, you know, he had the name and address of this one expert, and I know they can tell this, this, and this, and here's why she's important. If he had done that, despite the fact that his motion was lacking, would procedurally, would that be okay?
I believe so, Your Honor. He didn't, and the court offered him many opportunities, as they discussed it. It's probably a 30, 40-page transcript over this hearing where there were discussions of whether the state was going to bring, what witnesses the state was going to bring, whether they'd be declared an expert. And the court inquired generally multiple times, giving him the opportunity to expound on what he was wanting, and he never did. The only two types of information that he provided, one time he mentioned that lady from Tennessee Department of Safety, and the court attempted to aid him in getting that witness. And then the second one was, he said, I have 4, and never said anything else. And that's what's really the crux of this case, because as Judge Sixton, as you indicated, that the requirement is for the defendant to show at the time of the hearing, or the motion, or the hearing. You know, we really don't get to delve into what happened at trial and what was considered at the trial, what was brought forth. And as your honors will look at the transcript, he did a wonderful job cross-examining the state's witnesses as to his theory of the case. But you have to look at the time of the motion and the time of the hearing on that motion, and it was never developed. And that's why, at the end of the day, the court found no basis for the defense witness. He just did not provide a particularized need of any sort that would fit the criteria of Rule 13.
But Ms. Butler says at the hearing that he noted there were discrepancies and inaccuracies in the report. To what extent did that occur?
His exact comment was I need someone to counter this, either the state's theory or the theory. He didn't get any particular details of, was it the speed, what was the nature of the wreck. And truly at the trial, speed was never in contention at all. The defendant basically conceded the speed and the nature of his, he did not testify. The only comments we have in the record at all, it was he made a comment to the officer on the scene the night, Trooper Riviera, I believe. But beyond that, there was no testimony beyond that from the defense. And that speed was never an issue. The GPS and the data from his car showed that he was traveling for the 13 minutes before a wreck, if I believe accurate, was between 101 and 127 miles an hour for 13 consistent minutes prior to the wreck.
So as I understand his theory, this was not a rear-end collision, but he was sideswiped as the victim's vehicle had moved into his lane?
That was the only comment that he had. He commented that on the scene, and then that was his argument. Again, there was no proof as to that at trial beyond that one comment.
Didn't the black box report, though, contain a side impact reading of some sort?
Yes. So and this was dealt in detail through cross-examination by the defendant in this case of Trooper Moore, that the black box showed indication of side or front damage, definitely side damage, or side contact, I forget the exact term. And the spin out, and actually indicated a potential, I think it was a rollover. I think that might be the term. And during the cross-examination of Trooper Moore, and Moore testified that all those occurred, the damage, those indications as he was spinning out into the median. That was his testimony. And there was a back and forth, as counsel mentioned, of Trooper Moore was indicating his concern was the speed and nature of the contact. There was no indication of any braking by the defendant or the victim's vehicle before the contact occurred. It was the nature of the speed that the defendant was driving, not the post-wreck spinning out of the cars. That was the things. But one thing also, the defense, back to sufficient, just one moment, is, the state's position in this instance, the egregiousness of the speed at that continuous amount at over 100 miles an hour alone would be sufficient, but also the other factors to consider, the timing of this is 1 a.m, late at night, at dark. And also there's indication through the testimonies of the confession by the defendant and the testimony of the Trooper Riviera and Trooper Forsyth, the indications of not impairment, but marijuana use by the defendant at the time. And so those are other factors to consider, because if you look at one of the cases that talks about that, it was one of the factors in that case where there was indication that the driver, and again, a lot of the cases, there's not many cases on this subject, because it talks about reckless driving, but the state's position is that speed in this instance was so egregious, so excessive.
I want to go back to Judge Hickson's comment, question about, I mean, if the state is arguing, the state's expert is saying, this is how the accident happened, and the defendant gets at the hearing when asking for an expert and says, no, he sideswiped me, I'm not the one that ran into him, is that not enough for a particularized need? I mean, it's, to use defense counsel, I mean, it becomes a battle of the experts there, but you're not letting one party have an expert to have the battle.
But he did not articulate that in that specificity at that hearing. He did not. All he said it was, I think the quote is, to counter their theory, or their theory. I
Well,
think
when did, I mean, Judge Hickson obviously got it from somewhere that the defense's theory was that the victim had sideswiped him. Where did that come from?
The only place it comes from is when Trooper Riviera spoke to him on the scene, the defendant said that.
He didn't articulate that at the hearing. No one articulated that at the hearing.
No, he did not articulate that.
Right,
He said at the hearing, and that was his argument, especially with Trooper Moore when they were cross-examining as to that, and then closing arguments. But there was never any other proof beyond that one comment.
And I'm assuming that video hadn't been played to the trial court in a separate proceeding or anything prior to the...
I don't believe. I don't think there is a video of the interactions at the time. I think
I said video. Maybe the statement. The trial court,
Yes.
I'm assuming, wasn't aware of that particular statement.
No, I don't believe. There was no detail of that at that hearing. Well, if y'all have no other questions, I would ask you. Yes, sir.
I do have one question. How can the trial judge say, I don't know if I'm going to qualify them or not, we don't know yet, and then make the statement, but they're going to testify truthfully as to their opinions? Well, one, if he doesn't know whether or not they're experts, how are they testifying to opinion? And two, he's clearly making a credibility determination without even hearing one piece of evidence.
I think taking in context of the litigation that up to that point, that the judge was probably not artfully, but saying that that he would be given an opportunity to present his own proof, cross-examine the witnesses, voir dire them as whether they'd be determined to be experts, and given those opportunities. Maybe not as artfully as I would hope.
I mean, he said they're going to testify truthfully as to their opinions. That's the quote.
That is the quote.
The quote isn't, you'll be able to test their truthfulness if they are giving opinions. It is, they will testify truthfully as to their opinions. That seems like he's already made a determination without hearing any of the proof.
But later on in that same transcript, he does mention he'd be given the opportunity to examine them on those on that. So it's sort of cake and kind. Would I appreciate that a quote not being there? Yes,
Yeah, I
but it
understand
is there.
that. You didn't make the quote.
Thankfully, no. Thank you, Your Honors. If nothing else, I'd ask Your Honors to affirm the verdict of the court as well as the decision as to the expert.
Good.
Mr. May. Ms. Bottler, your rebuttal.
Thank you, Your Honor. Just a couple quick points. Just to briefly address the sufficiency, I just want to point out that today the state is talking about a lot of other facts and circumstances, which is precisely what we argued in the briefs, that that even Wilkins says in certain facts and circumstances, excessive speed can be sufficient. And this is actually the first time that the state has decided to mention other facts and circumstances. So certainly, as far as the proof at trial and the arguments that were made by the state at trial, the state argued that the speed alone was sheer per se recklessness. It didn't mention the time of day, the conditions of the road, any of that. None of that has been brought up until today in terms of that going into the sufficiency analysis. So I just want to point that out. The other thing is, I don't think that we've ever denied that the collision occurred. For sufficiency purposes, yes, we are taking issue with the analysis on the speed. But in terms of the argument about the expert, what we've always sort of said is that we wanted an expert to review not just the speed, but the black box data and all that that contains, including that discussion that they had about sort of whether this was a sideswipe or a full frontal collision. And so to the extent that there's some confusion about sort of what our theories are, I just want to make that clear that for sufficiency purposes, yes, we're arguing about the speed. But in terms of arguing that Mr. Tipton was wrongfully denied an expert, we're arguing about not just the speed, but the black box data in totality. The other thing I want to point out is that the state says that the evidence is sort of overwhelming. They had other troopers that testified about what they observed on the highway that night. One of the troopers at the trial actually testified that initially, sort of the initial review of the crime scene, or of the scene, they believed that both vehicles were traveling at highway speed. And obviously they came back later and said with the black box data, well, Mr. Tipton was traveling much faster than highway speed, but the initial sort of analysis was highway speed. And I think that sort of goes to the need for another expert to determine whether that data that Trooper Moore sort of, his analysis was correct on that. Last thing I want to point out is, actually, no, I do want to touch just briefly on the sort of harmlessness. The state didn't really bring it up today, but it is in the brief. This idea that it's harmless because the evidence is overwhelming. I would say that our argument there is the evidence is overwhelming, or the fact that the state can make that argument today is because there was not another expert. It can make the argument that this was overwhelming proof because there is one expert, one set of facts, sort of one narrative out there, and Mr. Tipton did not get the opportunity to present an alternative narrative outside of just sort of vehemently disagreeing with Trooper Moore's analysis. And just again, I just want to highlight just the fundamental fairness. Obviously, Mr. Tipton is constitutionally entitled to a fair trial. The trial court is not required to give him the best trial, the best fighting chance, but it is required to give him an adequate defense. And ultimately, when the state's proof is hinging on its analysis of the black box data, and Mr. Tipton is not afforded the opportunity to challenge that with his own expert, that defense is honestly about as adequate as a piece of paper. So we'd ask the court to reverse the trial court's decision and remain this for a new trial. Thank you.
Thank you, ma'am. Are there any other matters before we break for lunch? Okay. And the court will be in recess until 1:30 this afternoon.